Good afternoon, folks. This is Ed Walsh with NACA. We appreciate you being with us today. As those of you that have been on our webinars before know that I've got a few things to review with you before we actually get into the presentation. So I'm going to do that now. We're excited to have a presentation today by attorney Trent Coatney. He's an attorney and a partner with Adam and Reese law firm. Going to talk with us today about the legal issues pertaining to job costs. So I'll let you finish reading the rest of that slide. Then I'm going to go through my, oops, I clicked the wrong thing. For those of you that are new with us, you're going to see polling questions come up during the course of the presentation. You must answer them. And you also must remain on the call no less than 50 minutes if you are going to be seeking CPE. Those are the rules with NASBA. You're going to be muted during the sessions so that if you want to ask a question, please use the questions function and type it in. That way we'll read it as we go along. The slide deck is available after the presentation, recording also, if you want to re-listen to it. If you want CPE, you must request it. I have to follow the rules, so please send me an email and let me know you want the CPE. And then finally, if somebody can go to the question box just to type in that you're hearing us, we're coming through okay. So I'm going to close that out for now and introduce attorney Trent Coatney to you and let him take over. I'm going to transfer the screen over to his.
Great, thank you. All right.
You should be good.
Great. I will go ahead and start from the beginning here. Hopefully everybody can see that.
Looks good on my screen.
All right. So I want to welcome everybody. Thank you, Ed, and thank you, to the association for giving me an opportunity to speak. And I guess the first thing that I want to talk to you guys about is where
we're seeing just part of your screen. It didn't go to beginning, so we got kind of a split screen going here. I'd say all the way over to the left from beginning. There you go.
You seeing it now?
We're seeing it, and I think yeah, it's fine. That's good.
Okay. So I wanted to start off and just kind of tell you guys, I'm approaching this from a legal standpoint, right? So clearly you guys are accountants, you understand, a lot of the different aspects of job costing from that standpoint. I'm approaching things from a risk mitigation and from a legal standpoint. And a lot of what we do, sort of on a daily basis is have to navigate the issues on a very high level to determine what a party's damages are, right? It's pretty easy to kind of figure out actual costs. So if you are on a project, let's say, and somebody's owed money for work that hasn't been performed, you go through your payment applications, whether those are G702, AIA payment applications or other forms. And from that standpoint, you kind of figure things out and you go from there, right? So what gets a little bit more complicated is where you really have to determine and drill down into job cost for claims like a request for equitable adjustment, or if you're doing a delay claim. We'll talk a little bit about delays. Or if you're trying to figure out sort of a daily job cost amount. All of this is where it gets more complex. And this is the kind of thing where we act as sort of a chief kind of, leading things in the right direction, but we depend on the analysis in order to present our facts to, whether it's an arbitrator or a judge or a jury. I would say the majority of construction-related claims either end up in what's known as a bench trial in front of a judge or in front of an arbitrator. We do a significant amount of arbitration work, And oftentimes it's critical to have that third party provide information that really provides you sort of the input that you're looking for. So I'm going to move the slide forward. Do you see, I'm just making sure you see complying with the accounting standards?
Yes, sir.
Okay. So clearly there's a variety of set standards that you've got to comply with. But what I'm going to do is talk to you a little bit more about the legal aspects of that. Like what do you have to be concerned about from the standpoint of understanding your contract, understanding the interplay between customers, understanding the interplay between, performance, and finally, what is owed. So we're going to go through each of these. We're going to start with talking about exactly what the contract is, right? Oftentimes that seems simple, but it can be complex. We're going to talk about what the critical performance obligations are for your customer, regardless of whether you're on, the owner side, developer side, contractor side, you name it. We're going to talk about how pricing is determined based on the contract documents, because really that's sort of, the trench that you fall back into. That's what you look at to determine how something is supposed to be priced. We're going to allocate that price over whatever the term of the contract is, and then we're going to recognize revenue if that performance has been satisfied. So each of these are key components that you really have to break down to understand what the legal issues are with job costs. So turning to the next slide, what I want to talk about is a little bit more about identifying the contract. Now, you're probably thinking, okay, this is a lawyer talking about contracts. What is he referring to? It's pretty easy to look at a document that says agreement or contract and think that's the contract document. But we all know that oftentimes every contract that's out there will incorporate additional documents, okay? And I do a webinar on contract negotiation, and there's a lot of tactics that lawyers use, including myself, to help slide in provisions, right? To help get stuff past another party that they might not be looking for. And this is sort of a trick of the trade that I think is worth sharing with you. If you see certain terms in a contract, like one of the first things that you want to do is look at the first page or so, and it'll mention the contract documents. It'll say the contract documents include this agreement, AIA 201, the plans, the specs, the project manual. It'll list a whole bunch of different documents, okay? The key thing for you to understand is that every single one of those documents that are listed there are as much about the contract or as much a part of the contract as the document that says contract on it. So great example is, I assume most of you are familiar with AIA contracts, American Institute of Architects contracts. You will have a standard AIA 101 or 111 that incorporates 201. 201 is about a 40-page document that has all the meat to it, right? It's got all the key terms and conditions that go through payment obligations, performance obligations, what you can charge for, what you can't charge for. It helps delineate certain job cost, right? That document is rarely provided to anybody. It's just saying, hey, AIA 201 governs and is part of this contract. So you have to find that document, and you've got to make sure that you are looking at that and make sure you are putting as much emphasis on that document as you would the actual document that says agreement or contract on it. Hopefully that makes sense. If not, please ask a question. I'm happy to look at all of that as we go through. One of the things, and I do have a good question here, and this is kind of, even though it does deal with dispute resolution in contracts, and because we're talking about AIA 201, the question was, can I clarify the difference between arbitration and mediation? So great question, and I think this is probably worth pausing on a little bit just so that I can help you guys understand. So there's really three things that you need to understand. There's mediation, arbitration, and litigation, okay? Mediation is an opportunity for the parties to get together. It is confidential, it is not binding, and it gives you a chance to settle, okay? That's a basic understanding of what mediation is. It's not binding, it's confidential. Anything that you say in there shouldn't be used elsewhere. That being said, I love using mediations as an opportunity to obtain free discovery. Okay, so you can kind of find out what's going on in a case without having to spend too much to do it. Arbitration is like court, except you're not in court. Okay, and the predominant arbitration association is the American Arbitration Association. I am a AAA construction arbitrator. I serve in that capacity. And I can tell you that if you have a construction related case and you submit to arbitration, you're going to get an arbitrator that's knowledgeable in construction, right? So I just did an 8-day arbitration. And if that had been in court, it probably would have been 4 weeks because there's some efficiencies that you get. I can cut through a lot of the, for lack of a better word, BS that you would have in a courtroom because you just don't understand construction or understand construction law. There's benefits to having that, okay? But it's not in court. It usually is binding, although some courts have what's known as non-binding arbitration that gives you an opportunity to have your case, hear your case out and then make a decision. And then there's some ramifications based on that. But for all intents and purposes, arbitration is usually binding. So the parties, once you get to the end of that, that's the decision. And then we're all familiar with litigation. That's when you go to court. And normally you have a judge decide construction related cases, but you can also have a jury. Depends on what the parties ask for. So great question. Keep them coming. Okay. Back to identifying the contract. We talked a little bit about incorporation by reference, right? It's really important that you guys take a look at what is included in the contract. There's nothing worse. We had a cost accountant expert that I was grilling, and I got him on this. You know, I sat across from him and I said, okay, in order to determine job costs, what did you look at? You know, show me the documents you looked at. And he showed me, you know, the document that was titled agreement. I said, okay, did you look at the project manual that identified job costs? No, I never looked at that. Did you look at the plans and specs? No, I didn't look at that. Did you look at this, that, and the other? And then I ended with, well, don't you think you should have looked at that? And there's only one answer to that. Yes. Okay. So I gutted that consultant in about 10 minutes. So it's very important that you understand who's on first, you know, who's on second, that kind of thing. When you're trying to analyze job costs, regardless of whether it's for accounting purposes or it's for a dispute. Okay. Here's where it gets interesting, and I'm going to hit on this a lot. Okay. Change orders, unexecuted change orders. If it wasn't for unexecuted change orders, I wouldn't have a job. Okay. I spend more time litigating unexecuted change orders than I do probably pretty much anything else. So oftentimes you will get in a situation where you have to take into account extra work that's done on a project, and you have to determine whether or not that is truly work that is under the contract or whether that is something that was not approved. Okay. You get into having to look at dispute documentation, and disputed change orders can be very litigious. It can also be very problematic. You know, one of the things that we do is we record a lot of claims of lien. Doesn't matter what state you're in. Most states have some, you know, ability to record a construction lien on private projects. If you overestimate that lien by including disputed change orders that you don't have good backup for, you run the risk of not only having a bad lien, but, you know, all kinds of other damages that result out of encumbering that property. You know, it could be a potential big issue. So you need to really drill down into those change orders. I always err on the side of being conservative, and I encourage you to do the same, right? Unless you can definitively tell that something is a true job cost, you've got to err on the side of caution, right? One of the things that you really want to do as you're looking through the contract is there's usually a section or two that talks about payment terms. Okay, when does payment occur? Okay, and this is an important thing to understand because, you know, the simplest term is payment occurs within 14 days of receipt of payment application, right? Where it gets more complicated is where you have contingent payment clauses. So in many states, I can't see what states you're in. I'm licensed in 9 states and we practice in almost every state. I can tell you a lot of states have what's known as contingent payment, which means that, you know, the contractor doesn't have to pay a subcontractor until they're paid by the owner. So understanding whether or not you've got that obligation could potentially impact whether or not it's a viable job cost. Okay, I'm getting into the weeds a little bit, but what I want you to do is, the goal of this is to help you issue spot, right? It's to get you thinking about stuff that you might not have thought about before, because again, I'm approaching it from the legal side. Okay. One of the other things I look at is I look at the commercial substance of what was provided. Okay. So you're going to look at, risk, timing, amount of future cash flow that's expected as a result of the contract. Easiest way to do that is look at, percentage of completion or amount unbilled, and then whether or not collectability is probable. We just had a major contractor declare bankruptcy. Obviously, in that situation, collectability is not highly probable. So you need to factor things like that in. This gets more into collection related issues, but as the economy changes, and we're seeing that, it's sort of a slow change. Construction remains strong, and there's a pretty decent backlog out there, but collectability will become more and more of an issue. So obviously, understanding each project and the likelihood of viable AR, I think, is something that you need to at least contemplate. Next thing I want to talk about is I want to turn towards identifying performance obligations. Okay. So I've got a little, I won't read all of this to you here, but really what you need to understand, and at its basic level, your customer, whoever it is that you're doing a job cost analysis for, is providing some good or service in exchange for payment. Okay. If those boxes are checked, then you move forward, right? If there is some other issue, if there are intervening circumstances, if it relies on third-party authentication, okay, we've got certain situations where we're representing a contractor that does very high-end controls for industrial facilities, and in order for them to receive payment, there is a variety of boxes that they need to check. It's obviously, tender your lien releases, tender your payment applications, all that type of stuff. But it also required an independent third-party inspection of this control system. So you need to make sure that all the boxes are checked in order to make sure it's a viable cost and entitlement to payment. We get into a lot of situations, and have gotten into a lot of situations, where we need job cost accounting for performance bond claims. Okay. I want to explain what I mean by that. So on a project, primarily commercial projects, you will see them on larger residential, but on commercial projects, the prime contractor may normally post what is known as a payment and performance bond. Okay. There's two parts to it. The payment bond ensures that the prime contractor is paying the downstream subs, right? Regardless of whether a sub or sub-sub, okay? The performance is for the benefit of the owner or the developer. And what that says is that the contractor will perform pursuant to the terms of the contract, okay? We had a fairly sizable issue. This is a multi-million-dollar issue that we are dealing with right now, where we had to make a performance bond claim on a contractor that is defaulted as a result of some waterproofing work. Upwards of $15 million claim. And as part of this, we are having to do some extensive analysis of job cost, determine what is legitimate and what is not, and argue that back and forth between Sureties Council and the Contractors Council. And you can see where this becomes a Herculean effort, right? There's a lot that goes into this type of analysis. It's not as easy as tracking payment applications, because you really have to see which boxes were checked, what needs to be done. In this case, one of the key things that we're having to determine is expiration date of materials, whether or not, manufacturer inspections occurred, whether or not operator maintenance, manuals were provided. All those types of things factor into whether or not you can truly sign off on something. And again, look, I'm a lawyer, I'm conservative by nature, but I'm speaking to the same like-minded kind of group, right? And one of the things I always like to do in this is I recommend paper in the file, right? Understanding recognize that anything that you put down in writing is potentially discoverable, especially if you are serving as an expert. But it's nice to understand the means and methods that you took to unearth things, right? The documents that you reviewed, the analysis that you took. If you are, doing this in a dispute, work hand in hand with the attorney to figure out, okay, what should I be doing and what should I not be doing? Okay. Again, any questions on this, please let me know. So how do you determine a transaction price? Okay. And there's a lot of stuff that factors into it. It sounds easy, but oftentimes it's not. Okay. There's a lot of different considerations. We have a lot of customers that receive back-end rebates or refunds or credits or discounts, right? There may be additional consideration beyond cash. The ability to advertise or market, the ability to use displays, the ability to promote on social media, intellectual property. That often becomes a big thing, especially in for design professionals. All that needs to be considered. Royalties. We've had a lot of situations where there's proprietary software, proprietary means and methods that are being used, and there's a royalty attached to it, and you've got to factor that in. Okay. The other thing that you want to look at is what consideration is payable to the customer as opposed to third parties or any uncertainty that's out there. So if you are aware of ongoing disputes or questions as to entitlement to job cost, you need to take that into account, right? Financing plays a huge role. There's two things I hate in a dispute. It's when a lender is involved or when an insurer is involved, because it just makes things incredibly complex. And I really want to make sure that, if you've got a financing component, that you are taking that into account. The difference between what's provided as opposed to the cost of that. So whether it's interest or finance charges or other fees that are associated with it. So I'm going to turn to our first poll question. And this is something I'm just kind of curious about. We talked a little bit about unexecuted change orders, right? And as I said, I wouldn't have a job if I couldn't figure out a way around unexecuted change orders. But how do you deal with it, right? I'm curious to understand, do you guys include them within job cost? Do you review the documentation, and then if it looks good, you support it, or you just exclude it? Or is there something I'm missing? I want to know, you guys are the real brains behind the operation. I want to know, what is it that you do if you have an unexecuted change order, right? So that means that your customer has submitted a change order, has requested payment, but doesn't have it fully signed and it hasn't been approved for whatever reason, right? It could be disputed, could just be hanging out there. Let me know what you guys think, A, B, or C.
I'm sorry, Trent, I didn't notice, but I guess the second answer got cut off there. And no, it looks like folks
so it looks like I'm looking at the results, and this is kind of what I thought. 58% of you said that you review the documentation, and if it looks like it's supportable, then that's what you do, right? 33% of you exclude, which I also kind of assumed, and then 9% include them, right? And I think this is kind of it depends, right? It depends on what you're doing the job cost for. And I think that kind of plays into things. But I think that, B is a decent thing. You want to do some digging and you want to kind of see what it is. You don't want to be put in a position where you're having to make a ball or strike call, but if there's enough supporting evidence in there, I always say if it passed the sniff test. And I do the same thing with my lien claims. If I think that there is enough supporting documentation to evidence entitlement to it, I'll include it. I'll tell the customer, I'll say, look, just to let you know, this $50,000 that I included, a little bit of a question mark. I think you got a good basis here, but just wanted to let you know. And you tell me what to do. I always put it in their court, and they either bless it or they say no, be conservative. That way you're taking it off of you and you're kind of saying, hey, I saw this, I can include it. I'm seeing enough documentation to where I think it's a good job cost, but you tell me what you want to do. Okay. Keep in mind, we live in a world of CYA now. everybody is a Google lawyer. So it's real easy to make sure that you're paper in the file to protect yourself. I always say if it's good for you, you put it in writing, and if it's bad for you, you pick up the phone. So this is one of those scenarios where probably doesn't hurt to tell the customer, hey, this is what I did. Let me know if you disagree. Okay. Again, if this is in litigation or if it's a dispute, you want to think about it before you put that in writing. Work with your lawyer to figure out whether or not it's out there. Once it's out there, it's hard to reel back in. Okay. All righty. So recognized revenue. I know a little bit about this, and again, I can barely operate QuickBooks, so I'm not
seeing your. I'm sorry, we're not seeing your screen. We're not seeing your screen.
Okay. Let me go back here. So I see it on my end.
This has happened before. Let me do this.
Okay. So I will talk about it, and then if you can't see it, I'll try switching up views.
I'm clicking a few things here to see if it'll work. There it is.
Okay. So as I was saying, I'm not a numbers cruncher. I can barely use QuickBooks. I know enough about cash on accrual basis because I've owned a handful of businesses in the past. But this is critical, right? This is your bread and butter, and it's one of the things that you really got to make sure that you're watching out for is, are you on a cash basis? Is it on an accrual basis? Is it a completed contract? Is it percentage of completion? What is it that you're looking at, right? And easier said than done sometimes. Oftentimes you end up in a situation where you've got, you may have a percentage of completion that then goes sideways, and the customer may pay your contractor a fixed sum because of this, or there may be an allowance, or there may be stuff goes crazy, right? That's why we all have jobs. So, but the key thing is understanding the basis, because it is much different reporting job cost in a cash basis than it is an accrual basis. I know this for tax purposes, and so I at least know that much. But please watch out for that, because how revenue is recognized can impact how you report job cost on a project. And there could be some huge tax benefits to that, right? Part of what you do is analyze job cost, for various purposes, one of which is, understanding revenue flow and how that impacts the bottom line. Okay. Next thing I want to do is I want to turn to some basics, right? But I want to do it from the standpoint of legal. So what is job costing? Well, clearly it's project-based accounting that considers materials, labor, overhead. Can't consider other things, but that's really the gist of it. You add all those up, you get your total job cost. Again, that can be increased or decreased based on contractual terms. So I spent a little bit of time going over, key contract terms. Very important to understand what is considered a cost and what is not. Okay. Let me give you another trick of the trade that I think is worth sharing with you. Oftentimes I'm asked to negotiate contracts, right? I review dozens upon dozens of contracts a month. And we've got, hundreds of lawyers here, more than 100 construction lawyers. I don't know how many contracts we review a month, but it's a lot. One of the most difficult things that we have to do is we get a contract from a very large owner or from a national prime contractor that says, don't bother trying to review this contract because you can't change anything. Okay. And I appreciate that. I understand that, but rarely do I take no for an answer. It's just maybe. And I want to explain to you one of the tricks that I use successfully so that you can watch out for it. Okay. Don't tell anybody I told you this. So one of the things that I do often is when you're looking at a contract, if you see a capitalized term, there shouldn't be capitalized. So clearly, Florida is capitalized. But if you see cost or work capitalized, that means that somewhere in that contract, somebody defined that term. Okay. Now, one of the things I love to do is I love to define cost on the second page of the contract, never the first, but usually the second or the third page of the contract. I put cost, and I include a bunch of stuff that is favorable to my customer. So it could be stuff that's not normally cost, or it could be stuff that is normally cost, depending on who I'm representing. Okay, then throughout the rest of the contract, all you see is capital C cost, nothing else, right? So it takes your eye off of what that definition is. I'm hiding the ball intentionally from you, okay? That's a lawyer trick. So watch out for it. When you see a capitalized term, regardless of whether it's work, cost, what else? Labor, um, revenue, all those types of things. The definition of it, what is comes into play, because oftentimes you can change common sense definitions, and most people never catch that. You can bury stuff in there, so watch out for that trick because it's a successful one. Hopefully that makes sense to you guys. I want to talk a little bit about job costing systems. Now, obviously, you've got a lot of software at your fingertips, right? You've got a lot of different things that you use to help you do what you do, right? But a good job costing system, both internally within the customer itself and externally with what you use, is incredibly important, because I've always been a believer that data helps predict the future. If you have good data, you can easily predict what sales will be, what future revenue will be. You can figure out what markets to go into. I live and die by data, right? And I feel the same way about job costing. If you can understand and you have good analytics, if you have good software capability, it will take that burden off you and it will eliminate uncertainty. It is worth every penny of investment. The other thing is, I always like to follow a budget, even if it's for a job itself. I like to compare actual cost to estimated cost, right? So every single contract has a lifespan. It doesn't matter whether it's a day long or it's 2 years long. Every contract has a budget, and we look at that. We call it different things, regardless of whether it's, critical path through the use of Gantt charts, regardless of whether it's through, payment applications and understanding percentage of completion, or any other type of accounting document. But you always want to compare actual cost, estimated cost, and the goal is to always tweak that. So oftentimes estimators come into play here. It's if I end up in a dispute where I'm representing a contractor and they underbid that job, or they're way off at the end of the job, they need to fire their estimator, right? There's something happened wrong at the beginning to where there's nothing left in there for the end. I always tell any contractor that I talk to that last payment should be gravy on top of the mashed potatoes, right? Everybody loves you when they sign a contract. Everybody hates you by the end of it. So that last payment should be nothing but net profit, and that's how you should bid that project. Because the goal is to have every single cost, regardless of whether it's material, labor, or services, paid before retainage is paid out, to the extent that you can. Now, sometimes that's difficult to do, but really believe in that. The other thing that's useful is that if you've got all this data at your fingertips, it really provides historical data for future reference. So you'll know what projects are profitable and what projects are not. You'll have an understanding of what your net profit is per project, right? And that is a critical tool for any, contractor, trade, design professional, or owner and developer to have at their fingertips. I know internally what types of work we do as lawyers that is the most profitable and what is the least profitable. And I track that data and I use that data to move the team in the direction that I think will result in the most profitable work. Okay. You should do the same thing with job costing, right? Whoever your customers are, you can provide the same type of analysis, and you should be doing that. There's always an old saying that you spend more time on customers that are unprofitable than you do on the ones that are profitable. So really focus on that, because I think having good software, good systems, good standard operating procedures, it will really cut down a lot of time and increase efficiency. Turning to the next one. This is job cost broken down, okay? So what I wanted to do is I wanted to provide a little bit of analysis on kind of how I see job cost. Obviously there's, your accounts payable, that's where you go to see anything. But there's a variety of different things that kind of flow into that. You've got your purchases, regardless of whether that's materials or equipment or whatever it might be. right? You've got your subcontracts. So it could be trades, mechanical, plumbing, electrical, MPE, HVAC, roofing, whatever it might be. Inventory, oftentimes you got to factor in inventory. Inventory kills, right? What used to be before COVID and the material availability issues, we were just in time. We're not just in time anymore. We're more kind of just in time. Now that things have moved back a little bit, but inventory is a killer. So factoring that in is big. Billing, what do you have out there in queue? What do you expect in? What are the costs and administrative costs associated with that? Your general ledger, what does that look like? What's going in, what's going out? Obviously, balance sheet, profit and loss, all that factors in. Payroll, right? Before I merged with this firm, ran my own firm for 10 years. We had 100 employees, 350,000 every 2 weeks. Okay. That keeps anybody up at night, especially me as 96% owner. So payroll is a huge, huge, huge component. And there are other things, insurance, right? Insurance factors in surety cost. Surety premiums range from 2 to 4%, depending on the project size. All these different things kind of factor in. And I put off to the side here, equipment management. There are clever ways, and you guys are a lot smarter than I am when it comes to understanding this. There are clever ways that you can manage equipment from the standpoint of job cost and taxes. Okay, one of the things that we do on a higher level is creation of separate entities for purposes of holding certain equipment and leasing that back, both to reduce liability and for tax purposes. It's been interesting with the Inflation Reduction Act and some of the tax credits that have been available through that. We've had to get very creative, to help incentivize certain contractors, especially in the solar and renewable energy space, that are looking to maximize potential returns based on that. So just keep this in mind. Again, I'm not telling you anything you don't know, but what I want to do is just put a little bit of a high-level legal spin on it. So when you're thinking about it, you've got really what I break down into is 3 types of sub-cost. You've got general administrative expenses, and the key thing there is subcontracts, right? That's where the bulk of your pass-through type costs are if you are dealing with a prime contractor or general contractor. Selling expenses, and that's pretty much billing, what you get out there. And then pre-contract costs, things that exist already that you may have to continue to pay for, but obviously you're itemizing it per job, right? Payroll. All these are factored in for purposes of understanding sort of the do's and don'ts and what you should look at and what you should not. So we'd like to turn to a poll question now. Obviously, I'm a dirty lawyer, right? I've been talking to you guys a lot about, legal issues and disputes. I'm just curious, how many of you guys do consultant or expert work? How many of you guys work for the dark side? Let me know, yes or no. It doesn't have to be in court. It could be a lawyer hires you just to do some analysis. Yes or no? So we got, Ed, this is interesting. I got the results coming in. Looks like it's just about an even split, maybe a little bit on the no side. No, it's right there about even split. So let me tell you some pros and cons for working for lawyers, right? I personally don't like lawyers. Don't tell the great people here at Adams and Reese I said that. But I'd much rather hang out with you guys or contractors. That's kind of how I grew up. I grew up in family construction. It can be very lucrative work. Okay, doing consultant and expert work. There's some experts that charge more than I do. Very, very lucrative work, but very demanding. Okay, very demanding, and it is a lot of intensity. Not that it isn't demanding on the other side of it, but that's sort of the trade-off there. High dollar, high value work, but a lot of stress and a lot of demand, and you're put under the microscope. So not for everybody, but again, very, very lucrative work. Big demand out there for any expert. Hard to find experts. It can be a very difficult task. So interesting. If you're thinking about getting into that, obviously, make sure that here's some advice for you. Make sure you got a very good engagement letter, and make sure, just like we do on our end, make sure you're tracking that payment. Right? Track that payment, get that retainer, make sure you're getting paid. That's the key thing, because if the case goes sideways and that your lawyer ends up losing the trial, You don't want to be chasing a lawyer and trying to get paid. So there's some sage words of advice. So turning now to delays. I could do probably a 5-day course just on delays. One of the most complex and complicated things that we deal with on a daily basis. I almost always hire a delay expert. Most of the time, somebody with an accounting background, right? Because it is so complex. Okay. Now, I understand the law of delay. I can cite chapter and verse. I understand no damages for delay clauses. I understand Gantt charts and critical path and you name it. But when it comes to the math, I count on my fingers and I depend on people that are a lot smarter than I am on that. So, how do you calculate delays? Well, the first thing that should clue in about how complex it is that there is a formula for it. There's a variety of formulas, but one of the most prevalent is the ICLEA formula. It's a way to calculate unabsorbed overhead. Okay, basically it determines comp owed to the contractor for owner-caused delay. Can't use it on every project. Usually, I use it on government-related projects. But when does it apply? Well, you can use it if all the three following are true. Okay. Government delayed to contractors. So oftentimes I'll use this on roadway and horizontal construction. Government require the contractor to remain on standby, or there's a suspension during that delay. Had a lot of suspensions during COVID-19, a lot of suspensions as a result of material unavailability. That's why I've been knocking out this formula left and right. Loss of work. Contractor was unable to obtain other work because they have allocated a certain amount of crew to this project that can otherwise be used. Okay. How do you go about actually calculating it? Okay, this is where the math comes in. You use your contract billings over the total billings times total overhead, and that equals the allocable contract overhead. Then you do a second calculation, which is the allocable overhead over the days of performance, which equals the daily contract overhead. Then you take the contract billings over the total billings times the total overhead. And, similar to the first one, you end up with hopefully a total cost at that point. Now, I gave you the ICLEA formula, right? And obviously you'll get these slides so you can look at it in more detail, but there's a lot of different ways to calculate delays, right? A lot of different ways that you can use to look at delays. I've used most of these except for total cost, and I'll explain why. So measured mile compares an affected, multiple affected productivity periods to unaffected periods. So oftentimes I'm using Gantt charts to analyze critical path. And what I do there is I use the baseline of what the contractor's cost performance would be, and I compare it to the delayed amount, right? And obviously I'm looking to the consultant or the expert to provide actual information on what those costs are, okay? Fairly effective. There are ways to challenge it, but a decent method, especially on horizontal construction, to help determine delay. The jury verdict method, this is kind of a hodgepodge where you just kind of throw it up and pray that something sticks. It's distinguished from total cost because it seeks to calculate a specific extent of damages that flowed from the delay through expert opinions. So oftentimes what I'm doing is I'm relying almost 100% on the expert to say, here's what I did, here's what I came up with. It could be as simple as a daily job cost that's calculated over time. It could be more complex, and then it's put up. Okay, now normally what happens is we retain a consultant or an expert that cranks out a beautiful report, right? It's 4-color spiral bound. And the other side has their expert report. Then they get grilled at deposition, and then they fine tune everything, and then you go to trial or arbitration, and the same thing happens again. Okay, but this is sort of a hybrid model where you get to kind of say, okay, based on my best guesstimate, this is kind of what I'm seeing. A lot of different ways to challenge this. Keep in mind, as a consultant or an expert, I always look to attack from the flank. So what I'm trying to do is I'm trying to attack the underpinnings of a decision, not the decision itself. Okay, if I attack the decision itself, it's more easy to defend. if I go through and I start nitpicking at the foundations of what created that opinion, the whole thing will collapse. Okay, so it's death by 1,000 cuts. And oftentimes, if I am taking the deposition of a job cost accountant, it will be 2-3 days. I want to give you another trick of the trade, right? And again, don't tell anybody I told you this, okay? So when you're sitting in deposition, for those of you, for the 50% of you that don't do lawyer work, God bless you. Hopefully you'll never sit in deposition. For those of you that do lawyer work, this is important to understand, okay? I always like, especially with experts, they have done this plenty of times before. They are used to testifying. They're used to dealing with lawyers, okay? So you got to wear them down. And this is what I like to do. Now I'm talking to you now. We're on the 40th floor in a high rise in Tampa. I put them in the conference room. I make sure the air is just right. In the morning, there's a huge display of donuts and bagels and, one thing of coffee, but not too much. And then we get to the midday. I always order lunch because I'm just a nice guy, but it's a heavy, heavy lunch, right? I'm ordering that Olive Garden tour of Italy. It's coming in, right? And we're eating chicken parm, unlimited breadsticks, you name it, okay? And then all of a sudden, it starts getting a little cooler in there, get a little bit more comfortable, right? I make sure I turn down the shades. We got one of these automatic fancy things that clouds the windows. That just so the light goes down. And then I wait till about 2 or 2:30, and I pull out. I've got question set number 1 and question set number 2. That's when I start really going to town, right? And it's a mental war. What I'm trying to do is break the other side, and you can see it happen. You can see the other side wear down to where they just don't want to play anymore. And that's when I save and I ask the best questions. It is all psychology. Okay. And you need to understand that this is not a conversation, it is psychology. So when I am prepping a job cost accountant that I've hired, I say, stay frosty. Okay. Bring your own coffee. If you need to smoke, take a smoke break. Whatever it is that you do to stay awake, you need to do it. Do not get lazy. I will kick you under the table. I don't really do that, but and I'll, whatever it takes for you to make sure that you are staying alert, you need to do it. But it is a trick that I employ often, and sometimes that is the only way you can soften up a hardened expert is just wear them out, and it requires you've got to be on your game too. So just letting you know that, when that 2 o'clock, 2:30 rolls around, make sure you're getting that extra caffeine, have that Red Bull ready. Okay. Talking about a few other things here. Total cost method. Total cost method almost everywhere is courts don't like it. Courts don't like it because it is too speculative. They prefer modified total cost, which is calculated the same way as total cost, but it often deducts self-imposed damages. So it's looking to be more conservative in nature. I don't ever present total cost because the case law out there is just bad on it. Okay. I prefer modified, and actually I like measured mile a little bit better. But these are some ways. There are more ways. I'm just giving you a handful. These are the ones that I've used over the years. So got another poll question here. Which method do you guys use the most to calculate delays? Do you do a per diem? Do you do total cost, modified total cost, measured mile, jury verdict, or something else? Maybe there's something else I missed. If there's some other way that you like to calculate delays, hit it up in the chat method or the question method and let me know. So interesting here, Ed. It's there's no right way or necessarily wrong way to do it. The key thing is figuring out a way that is the least challengeable, if that makes sense. You're always trying to figure it out from the standpoint of what is, regardless of whether you're doing this for a request for equitable adjustment on a federal case or you're doing this in court, what is the least objectionable? And this is interesting, Ed. We've got 47% modified total cost. Yep, and I agree with that. That tends to be a very prevalent way to do this. Total cost behind that, and I still see that a lot. I would encourage you, there's a lot of case law out there that cuts against total cost. It scares me when I go in without trying to account for some deducts in the modified total cost system. Then we got per diem and measured mile, 2% jury verdict. Yeah, all pretty much spot on. That's kind of what I see out there, and good results. So I want to close with some additional thoughts for you. Then I'm happy to answer any questions that you guys have. So as job cost accountants, part of what you do is an art. Okay, it's not just numbers. It's not just looking at documents. There's an art to job cost accounting. There's just like there's an art to being a lawyer, right? There's never black or white. It's always gray, right? Job cost accounting, a little bit more black or white, right? But there's a touch of gray there, right? So the key is understanding what the contract says versus reality. Okay, you understand what the contract calls for, but you have to be able to talk to the customer. You have to be able to look at the correspondence and understand what happened in the field. Because oftentimes what happens in the field may differ from what you see in the contract. The parties to a contract can orally modify any terms in there, okay? Even if there's a written, change order requirement. Oftentimes, course of conduct in a project, not every state, but most states allow course of conduct to modify contractual terms. So make sure that you are taking a holistic approach to this, right? Very important. Next thing is be careful when accounting for disputed change orders. Okay, extras, claims, delay damages, any of that, right? All of that can potentially be a point of contest. So make sure that you are looking at all supporting documentation, do an analysis, look at the correspondence back and forth. Look at it and make an informed decision based on your experience, okay? Absolutely follow the standard accounting principles and whatever industry resources are out there. This association had the opportunity to really look at it, a lot of tremendous resources out there, a lot of thoughtful content that you can rely on, in addition to standard accounting principles. But being able to cite chapter and verse of certain things, I think, is very important. Okay, document your standard operating procedures for how you go about doing it, and make sure that you're following that. Okay, so that if someone says, okay, how do you approach job costs, you can say, here's what I do, and this is exactly what I did on this project. Okay, and then understand risk mitigation. Part of what I try to explain to third parties, regardless of whether they are vendors or insurance agents or accountants, is understand that yes, you are performing a job. Okay, you have a job to do, but imagine if a dirty lawyer gets a hold of whatever you're producing. Okay, and I've subpoenaed plenty of accountants. They will routinely assert accountant-client privilege, which I get past, and I will look at all those notes and the documentation that's on there. So always remember, if it's good for you, put it in writing, and if it's bad for you, pick up the phone. Remember that anything that you put down in writing is potentially discoverable. Okay, so sometimes less is more, unless it's not enough, and then you need more. So how about that for a lawyer answer? So
Yeah.
that's kind of, some general thoughts on it. And, Ed, I kind of want to turn it now over to you guys and see if there's any questions for me. We went through a lot of different things. We covered a ton, and again, high level legal standpoint, but I'm curious to see what questions the audience has.
Well, folks, go ahead and fire away. We had a couple come in.
Oh, here we go. Yeah, I got it right here. Where and how do you account for and determine the amount of home office overhead and job costing and delay claims? So great question. Again, you guys are a lot smarter than I am when it comes to this. So obviously I defer to whatever the accounting principles are and whatever standards you have, but I'll tell you what I do. Okay. Oftentimes what I try to do is I try to figure out what home office overhead is, and oftentimes I'm asking the customer or the contractor to provide that, or the owner or developer, whoever it is, to provide that information and then allocate it over the job duration. Okay. There's a difference between home office overhead and job overhead. Okay. So there may be specific overhead assigned for a project. Like, for example, you may have a trailer. That's different than the lease that's paid on your home office, so all of that's kind of factored in. What I like to do is ask the contractor if they have a per diem that I could potentially apply to that. Again, I oftentimes am deferring to a consultant to do the final analysis, but ultimately what I'm doing is I'm trying to allocate whatever the home office is over the duration of a project. Now, duration of a project gets into things too, because if you factor in delay, sometimes there may be a dispute as to who caused the delay and whether or not that job cost is truly allocable over that entire duration. So not to get too much into the weeds, but yeah, that's definitely a good question and not an easy answer by any means. So what else do we got up?
Well, there's a comment, if contractor pays subs retention and has that pure profit at the end of the project. Yes. I'm sorry, I'm having trouble reading this. If contractor pays subs retention and has that pure profit at the end of the project, have no leverage over the subs to complete or correct work.
Yeah, so let me clarify my statement. From the customer standpoint, upstream, you want as little retainage as possible, right? So if I'm a prime contractor, I don't want the owner to take out any retainage. Downstream, I want as much retainage as possible. So I definitely want my subs to have, the maximum. Some states limit it by statute, so that you can't have, for example, more than 5%. But if you can, then I like to do at least 10%. I don't mind 50%, 5% upon 50% completion. So upstream as favorable as you can get it to you, downstream as onerous as possible. Hopefully that makes sense.
And I guess we'll have time for one more question. If an owner signs a change order that wasn't calculated as specified in the contract, let's say the fee is supposed to be 5% and they calculate it at 7% in the new change order, is that a clerical error that can be corrected? Are they stuck with it for that change order only, or did they change it?
Good question. Great question. So this is getting into contract law, right? So a change order is basically an amendment to a contract. That's what it is. So once it is fully signed and executed, then it is as much a part of the contract as the contract is itself. Change orders normally account for a variety of things. It can be an additive change order or a deductive change order. It can add cost or it can add or subtract time, right? So if there is a clerical error in there, are the parties bound to it? And I'll try not to give you a lawyer answer, but it depends, right? So if there's a clerical error and it was negotiated and that was the price everybody agreed on, then I think there would be a good argument that this was a negotiated price and we agreed to this. Okay, if it was clearly a mathematical error and everything was included, all the backup supporting documentation showed it was off by 2% or whatever it was, and it was just a math error, I think that lends itself to a better argument that, it is a typographical error that should be adjusted. But from a contractual standpoint, once it's fully signed, it is as much a part of the contract as the contract.
Well, we're coming up on the top of the hour, and I know folks probably have to get back to what they were doing, but I really want to thank you, Trent, for giving us your time and your expertise today. That was a great presentation, and I know there'll be follow-up questions. I wanted to recommend to everybody that's on the call today, follow Trent on LinkedIn. That's how I first found him. I'm sure Trent will be happy to connect with you on LinkedIn. Great stuff, great articles, I think almost every day, if not definitely every day. So that would be my recommendation, is connect with him on LinkedIn, and you'll find the content to be great. So with that,
let me say this. If any of our listeners want a specific topic addressed, I'm always looking for content to write on. I've got, I put stuff out on price acceleration provisions, liquidated damages, delays, all kinds of stuff. But if there's a specific topic you'd like me to write on, let me know, because, it's hard to come up with a topic almost every day. So. Yeah,
that's very true. And I would be happy to hear a lot of you folks did join up with Trent on LinkedIn. I think it's well worth your time to do that. So without further ado, I think we're past the top of the hour, so we'll wrap it up now and thank Trent for his time. And we'll hopefully hear from you again somewhere down the road if you have the time available, and we'll wrap it up for today. So thanks
Sounds
to everybody
great.
for
Thank you, guys.
staying with us. All right. Thank you, sir.
Appreciate it.